I want to thank you to our panelists that I'll introduce here in just a second, and to everyone who is joining us on Facebook Live. I'm Carol Seal. I'm the CEO for Greater Chattanooga Realtors. And, you know, in light of recent events in Chattanooga and all over the country, we've had lots of conversations about diversity and inclusion. And today's topic is just along those same lines of other ways that we can be sensitive and educate ourselves and inclusive in our community, and especially when it comes to property management. So today we're going to talk about navigating service animals and support animals in property management. And in just 1 hour, we're going to talk about some of the legal ramifications of that and best practices. We have several of our members on, and then other people from the community who are going to share their insight. And also, I want to give a thank you to Josh Branham, who is our communications director. About a week and a half ago, I said, "Hey, let's do this program," and he jumped right on it for me and pulled together the masses. So you'll see on our webinar today, we have Joni Eldridge, who is a realtor, and she is with Greyhaven Realty Management Company. We have Toni Morgan. She is with the City of Chattanooga. She's a compliance officer, specifically in the areas of Title VI and ADA compliance. We have Brittany Grant, who is representing the Chattanooga Apartment Association. We have Robin Ring, who's a realtor with River City Property Management. And we have Jennifer McCoy, who's an attorney here in Chattanooga, and hopefully also joining us before we have to close out, Jason Weathers, who is also a realtor member, and he's with Aubin Realty. So we're so glad to have each of you with us, to spend time with us this morning and to hear your insight. So let's get started. Let's just start with the basics. So this is an area that personally I don't know as much about as I need to know, but let's talk about what's the difference between an assistant animal, a support animal, a service animal. Is there a difference? And if so, what are they? And who wants to start with that one? Toni does. Go for it, Toni.
Okay, so the difference between a service animal and an emotional support animal is that the service animal is an animal that is being taught to produce or to do a task for an individual that is disabled, versus an emotional support animal is more there for comfort purposes.
I was actually just about to post it on that because we're...
I've texted Josh to mute himself. I don't know if that he can hear me.
Our Facebook page at all when you click that link.
Okay, hopefully. Jennifer, did you want to add to any of that? Because I know you get a lot of questions about the distinctions.
Yeah, so service animals are individually trained to carry out specific functions to help an individual with a disability. Also, a fun fact, a service animal can only be a dog. So if we're dealing with any kind of other animal, like say a turtle or a miniature horse is my favorite, that in order to be an assistance animal is going to follow under the emotional support realm. Okay.
All right. That's helpful. What classifies, and I think you just answered it, just to reiterate, what classifies a service dog under the American with Disabilities Act? Like, go a little further for us.
So it has to be a dog, like I said, who was individually trained to carry out a task of daily life for an individual with disabilities. You know, the ADA applies to areas of public accommodation. So we're talking about your hotel, your restaurant, your pool, where in housing, we're more concerned with the Fair Housing Act and those duties that we have to carry out regarding service and emotional support animals.
Right. Okay. And Toni, from the city's perspective, is this something that you all see a lot of complaints about? Is there a trend?
I do receive a lot of calls from constituents regarding issues of reasonable accommodation when it comes to service dogs. Just recently, I had a call from an individual that came to visit Chattanooga, and the hotel was not letting her bring into the dining area her service dog. So, my job is to educate and inform people, again, what are the rights under ADA, and also, if possible, communicate with the entity to, sometimes they just don't know the law. Sometimes they think that they could do that, but nevertheless, my job is to educate, whether it's the constituent or the entity, just to ensure that they understand what the law states and what are the rights of individuals who are disabled with
Gotcha.
public accommodation.
Gotcha. Okay. And I don't mean to leave Brittany, Joni, and Robin out on this. Any comments on that so far?
I do have a question in regards to if it's a single resident home that an individual has decided to rent out, Tony, regardless if it's a service or a support animal, there are about approximately 7 different kinds of breeds that the property owner's insurance will not allow, given the nature of that breed. So if in the event that someone should have a service or a support pit bull, for example, however, the property owner's insurance says that they cannot let their house out to an individual with that type of a breed of dog, do the laws trump all that?
Yes, I'm sorry to say yes. The federal law supersedes any of that. And when it comes, we do not have an excuse to say, let's say a pit bull. If the animal provides the service under the ADA guidelines or fair housing guidelines, in this case, with housing, then there should not be any a denial of service or to have that resident to be able to have that animal. And Jennifer could correct me on that.
No, she's exactly right. And I would just add that it's something that we mess up a lot is we need to be aware that support animals, assistance animals are not pets. So no pet rules apply to them. Not breed restrictions, not weight restrictions, none of that. They're animals and they have to be treated completely separately outside of your pet rules. Now, it's important to note they can't do damage to your property. They're not allowed to not be cleaned up after. You can police them in that way, but we just can't get into worrying about their weight or breed, unfortunately.
And Jennifer, correct me if I'm wrong here. Under the Tennessee law, you should allow the individual regardless of the breed. Nevertheless, if the animal does do any damage to the property, the constituent or the recipient of that service animal should pay for any damages.
Yes, 100%. They are still beholden to all of those rules for property management and your general rules about, you have to have an animal on a leash. You have to pick up after it. Yes. We can hold them responsible for all of that. Thank goodness.
Are you allowed to charge a pet fee like you would for? Okay.
No.
And is that a federal law or is that very state by state? Your comment because.
Federal law.
Okay.
It's federal, yes.
Our market area, as you know, covers both Tennessee and Georgia. I want to be sensitive to our Georgia members who might be following along on Facebook Live. Yes. What are the requirements to train a service dog? Are there some minimum things that have to be met?
Well, I'm going to jump in there. So basically no, you don't have to have a specific training. You don't have to have a professional trained animal. The constituent could do so. As long as the animal performs or assists with the specific disability, it could be considered a service animal. Again, just to make note, if the animal is in the training process, is not protected under the ADA guidelines. The animal should be already trained to perform the task, just for clarification purposes.
Okay.
Fun fact about that. So that's exactly right with the Fair Housing Act. But something I learned a couple years ago is we have agricultural statutes here in the South and in Tennessee that tell us on a state law level, we cannot disallow an animal who is undergoing that training to become a service animal. Yeah. So it's come up several times where we have individuals who are actually the dog trainer. They're not disabled, so they're not protected under the Fair Housing Act. Mm-hmm. But nonetheless, we still need to allow the animal. That was news to me. Fun fact.
Mm-hmm.
Thank
What
you for
about a
sharing that.
canine dog? What about a police officer that has a canine dog? Is that considered, is that fall into any of these categories?
My understanding is, and Jennifer, you could jump in there, they're a working dog. That is the category, but they're still pretty much a pet. They're not considered under the ADA, is my understanding.
That's exactly right. So when we're talking about ADA or FHA, they're not covered. But again, sometimes you get into state statutes that allow them. I know I do a little bit of HOA law as well, and there have been a lot of cases, especially like coming out of Florida, where a police car, for instance, the HOA said you can't have your police car parked here; it's against our rules. And so the homeowner police officer sued the HOA and really cleaned up on that. So I like to extrapolate this into kind of being the same thing as a police car. I couldn't find any cases where this has actually been litigated, and I really wouldn't want to be the test case on that.
So if I'm understanding correctly how you answered Joni's question, if I'm a police officer and have the canine dog, that's considered my pet. So all of this doesn't apply to me when I'm looking for housing.
Exactly.
Right. Okay.
At least as far as the federal fair housing and ADA go.
Yeah.
Okay.
Your state law may differ, but
Yes.
I don't think it's actually been litigated out as to a canine yet.
That's right.
Okay. So what about as our members and members of the community who are managing property and in that landlord role, and Brittany, who's with the apartment association, what are the reasonable and right ways to validate that the need to accommodate a service animal request?
Are you saying what can you ask, or how do you?
What can you ask? How can you navigate that conversation? We were having an informal one before we went live, and so I feel like we've already talked about it, but our listeners didn't get to hear it.
Yes. So
Joan,
I'm sorry.
It's okay. I was just going to say, Joan, if you want to bring up the pet screening website that you had brought up before we went Facebook Live, that is a good example.
Yeah, petscreening.com is a service that is out there for management companies who will help you navigate the pet screening process. So it kind of allows you to kind of step back. They process those applications. And this is for all pets, not just, those type of things. So if they have a special accommodation or a need, they do that through that application process. And then they document everything for you. So it's a service that you can look into. Again, we do not use that here. But it is something that you might want to investigate if you're doing that and you're just not sure. It's a pretty neat service, and it's something if you're not sure or you've never had to navigate it before, that they might be able to help you walk through some of those processes.
And for some people who do not have access to a computer, or there's only two basic questions that you could ask a disabled individual. You cannot ask about their health. You cannot ask about the specific disease or whatever that they might have. You could only ask if the animal is to provide a service, or is it providing it is the animal needed because of the disability? And second, what is the work or the task the animal performs for you? That's all you could ask.
Now, I've heard of some management companies having a form that they require to be filled out also. Does anybody know anything additional about that?
I do.
I think that
You
that's
do?
a good
Okay.
idea in regards to keeping agents protected, because if agents are dealing with individual property owners, these individual owners, you might have 5 owners that want 5 different things, and one form can kind of keep everyone more compliant and keep everyone out of trouble, because you as the agent, you want to satisfy the owner, but you're also you're kind of caught in the middle, and so it can get very, very sticky. And so I think that would be a very good idea for, as far as protection is concerned, for all parties.
So Jennifer, would a health individual, like, who would fill out the form? The resident, or?
So I want to talk about the forms in general. I completely agree. It's a great idea to have a form because we always want to make sure we're treating everybody the same. And the way we do that is if we have good protocols in place and we ask for the same information every time. However, I do want to make sure everybody knows that HUD tells us that we cannot require someone to fill out a form. So if they say, I'm not filling out this form, we can't deny their request just because they refuse to do so. And those requests don't have to be made in writing. They can be made verbally. But to answer your question, Brittany, usually these forms that property management companies use, usually it's the individual fills out a form making the request, and then a third party will go ahead and also fill out part of the form that says, yes, this person needs this animal, for this reason.
But we can't require them to fill out the form.
So we ask them to fill out the form. That's usually just part of our standard process. But if they refuse, we are not able to then decline their request for accommodation just based on their refusal to fill out that form.
Instead of having a separate form, could you not incorporate some, specific verbiage on your application? Because your application is where you're getting your pet information to begin with to find out if each individual has a pet or not. And so could you not have like a little disclaimer box underneath it in regards to, if it's a service animal or a support animal or something along those lines?
I think you could, but I know in the real world, we don't really want to probably give people the idea to check that box and say, service animal, yes, absolutely. Now I don't have to pay that fee. So that's why I would shy away from that, just because I don't like to give them that idea because they'll probably go to Google and find it on their own. I don't want to make it easier for them.
Then nobody has a pet anymore. Everybody always has service animals and support animals.
Yes, exactly.
And I think we need to delineate between a service animal and an emotional support animal because they have very different roles, and the guidelines are a little more gray, I think, on the emotional support animal versus the service animal. I understand the service animal. And like I said earlier, most of my tenants who have a service animal are very forthcoming and very open about it. I mean, you don't have to ask them. They are willing to inform you.
Exactly.
It's the emotional support animal that I have found to be the more
made up, fake.
Yeah, pretty much. Thank you. I was trying to be politically correct here, but yeah.
Thank you. Since we are recording this, I appreciate it.
And so that's kind of the issue that you run into, and so because we've had tenants who it was a roommate situation, and it ended up all 4 roommates had an emotional support animal. So, it can get a little bit confusing, I think, in that application process and determining whether or not this pet is legitimately an emotional support animal or just, I printed a document off of Google and there you go. So I think that's where a lot of people have problems.
Does anybody have anything that they recommend when we do receive, on the apartment side specifically, when we do receive the I bought this online letter from, like, how do you recommend verbiage wise to be like, this is fake?
Well, even though if it is an ESA or not, if you do have an ESA, you still have to have a prescription prescribed from a mental health provider, correct?
It doesn't have to be, from my understanding, it does not have to be a mental health provider. It is just anyone who can say, it can be their mother, it can be their cousin, but they can just, it does not necessarily have to be a mental health provider, is my understanding.
I would like to make a note of something, and again, Jennifer, you're an attorney, so you could clarify this, but under Tennessee law, the Tennessee law is pretty much parallels the ADA guideline regarding the service animal. What the Tennessee law doesn't cover, you remember that the fair housing, the federal law comes in and covers. Mm-hmm. For example, the fair housing covers the emotional support animal. So when you consider the law of under the state of Tennessee, of course, you would know that the ADA covers, again, service animals. And what it doesn't cover, then you got the federal law.
Mhm.
So what I'm saying is, for those of you folks who are doing property management and so forth, you got to consider those two avenues, because if you just go by saying, well, it's not a service animal, it's an emotional animal, you might be violating the law if you regarding the federal side when it comes to emotional support.
How
So
so though? So how is an emotional support animal allowed under the Fair Housing Act?
Under the Fair Housing Act, again, it not only covers the ADA, but also covers the emotional support. If the animal is providing, let's say somebody who has anxiety issues, if that animal is providing the comfort to that individual, then it falls under that protection. Again, if the animal is just a pet, it's not covered under ADA or fair housing. Am I correct here, Jennifer?
I think we've.
I'm sorry, my internet was skipping out there a little bit, but what I caught was exactly correct. I just want to add on that, unfortunately, the standard is very low as to what is required to have an emotional support animal. Essentially, you need a notification that says that that individual has a medical need for it due to their disability, and that the animal helps them with that. That is all that is needed. And again, it doesn't even have to be by a medical provider. So a lot of times you have people that will go online and get a certificate that says, this is my ESA.
Yeah.
That's not good enough, because that certificate doesn't tell you that they have a disability and how that animal helps. But they can also get a letter from a therapist or literally any third party with knowledge of the disability that says they need that animal, and then therefore we have to let them have it. Something I try to do to combat this is I sometimes will call the alleged provider that wrote the letter, because I'm finding too that people write them themselves now. So, you might call at least and do some level of diligence to see if that letter really was written by that party. And sometimes you can catch them that way. I would add that, we've engaged in some lobbying to try to get the rules to be a little stricter. Like, maybe the provider needs to actually be inside the state, or maybe they had to have met them live and in person. Today, none of that's required.
So Jennifer, you mentioned earlier that all service dogs or all service animals are to be a dog. However, as far as an emotional support animal, can it be anything? Can it be, you've got this emotional service snake or pig or something other than a dog? Because what I'm to understand is it says that there's no specified limitations with respects to different species.
I'm sorry, under ADA, as we stand, it's a dog. Under service animal, it could be it could be a ferret, it could be a bird, it could be a pony. But under ADA, they specifically, recommendation is a dog.
For a service animal.
For service animal. Emotional support, it could be any
Anything.
type of animal.
Now, let me ask you this, Tony. If the animal is a pony, what about city zoning? Is that waived for that type of thing as well?
Yes.
So if you've got a a quarter of an acre and you've got a pony and your neighbors,
then the ordinance of the city applies in that case, because you got to consider the weight. You got to consider. I don't know if you guys remember the chicken ordinance that there was going on a couple of years ago. So you got to assess those factors there when it comes to ordinances, and also the weight of the animal if they're on a second floor and you got a pony, that sort of thing. So that remember that is not necessarily covered under the ADA, but it's covered under emotional support. So, and Jennifer could clarify more regarding the law, what it states. But nevertheless, if it's a pony versus if you live in an apartment building and you have specific, because of the weight of the animal and so forth, if it's a burden, then it has to be proved what kind of a burden it is for the property owner.
So we touched on what questions are okay to ask when it comes to service animal, and it looks like Jennifer's back with us. We had a little bit of, welcome back. Thank you. Are there different questions that can be asked or should be avoided when it comes to navigating? And I think this goes back to Brittany's question. When you get a letter, how do you really know that it's okay? And Jennifer gave us some good ways to navigate that. But what questions are okay to ask as you are kind of digging into, is this really an emotional support animal, or that we should definitely avoid?
So really, we're not ever going to dig into the issue. Like, we're really allowed to ask two questions. Do you have a disability, and does this animal help you with that? Or how does this animal help you with that? That's about it. We can't get into the nature, extent of the disability or the diagnosis, none of that. You know, unfortunately, you know, I'm sure all of you see these letters every day. It's from some, you know, therapist or doctor, and it just says, Susie is my patient. Having this animal helps her with her everyday life. Thanks. Unfortunately, that's all we need.
And that's for emotional or service. Okay.
Yeah. With service, you know, if someone has a disability that you can see, and you can see how the animal helps with that, like maybe a seeing eye dog, you're not asking any questions at all because it's all obvious. Sure. You're only asking that question if they have a disability that's not readily apparent. And then again, it's the same line of questioning, you know, do you have a disability? How does this animal assist you with that?
Does that help answer your question a little bit, Brittany?
Yes.
Good. Okay. Joni, did you have something you wanted to ask or chime in?
Well, I was just going to say that some states, I think, have implemented that if you have a healthcare provider for an emotional support animal, they must be within your state. Is that in violation of fair housing, of the federal law, or is that something that each state can do individually?
So even if a state passes that law, that doesn't make it a law, you know, on the federal level, yeah, which for the purposes of us running our businesses, doesn't stop us from getting a fair housing claim. So we might be able to say, well, my state statute says I can do that. Well, ask me how much HUD is going to care about that. They don't.
Yeah.
Yeah, they don't.
I will say, you know, a tiny bit of good news is, you know, last July, Tennessee passed a statute that makes it an actual crime to pretend that you need an ESA when you don't. Yeah. That's great information, and it's good to share with applicants who we think are maybe being a little shady. But again, in real life, I don't think any of us are going to pick up the phone and call 911 when we think someone is lying. But it can maybe be a bit of a deterrent.
Right. Well, I wonder back to, I can't remember, Robin or Brittany asked that, about what you include on your application. Would you all recommend adding that verbiage that in Tennessee it is a crime, you know, just to put it out there to discourage bogus emotional support animals? Or does then that get us into the caveat of, oh, I'm going to say that I have one, like you were suggesting?
I love putting that on an application now because it is a bit of a deterrent, and maybe not necessarily at the application, because usually on the application we're not necessarily asking about someone's need for a service animal, but later on that reasonable accommodation form, that's a great place to put it.
Okay. And that was just passed this year or last year?
July of last year.
Okay. Okay. We were talking a minute ago about, you know, maybe some things can be done on the legislative level, which is that something as realtors that we maybe would want to get into the conversation on at the advocacy level. But I'm curious, I think, Jennifer, you mentioned maybe that healthcare provider should at least have met the person in person. Well, let me throw a wrench in that. Now we're in the midst of COVID and telehealth. So any additional thoughts on your previous comment related to that? How would you further qualify?
Well, I don't think it's ever that was like a grand scheme on my part, but I don't think that would ever be something that would be approved, because like you mentioned, especially now because of COVID, but also, and even more importantly, if I am a disabled individual, I might have difficulty making my way to see someone live and in person. So that probably would never be required. I think something that might be more reasonable would be the provider is actually maybe licensed in the state where the residence actually is. I think that might be a good first step, because I know every day, we're seeing letters from a therapist, and I have one in Jupiter, Florida, I see like every other day. So it might be nice if we had some kind of standard to keep them in state, but right now we don't.
Sure. Other thoughts on that from the group? Because I'm just curious what other potential legislation might be a help in your business to help clarify things even further or give you guidance.
I would love to see that on a federal level, not just on a state level, and that if you have an emotional support animal and you have the documentation needs to be a little more refined, a little more specific, in the sense that you can't just go on Google and print off because I had a friend that I met through NARPM, and they were talking that, they were there, they said it's an emotional support animal, and they said, well, do you have any, do you have your certificate? They went over, Googled it, printed it off there in his office and handed it to them. I mean, it's that simple. So, I would like to see those type of sites not be allowed. In other words, you can't just print this stuff off from wherever. I think that would be a wonderful legislation if you could get something like that. Or the therapist who just writes letters for whoever they want to write. You pay me $60 and I'll write you a letter.
I agree. I mean, it's a prescription, and you can't get your drug care covered unless you've got a prescription from your doctor. So it's kind of, maybe needs to be treated the same. It's a good idea, Joni.
I think that would be the federal legislation I would like to see. And I think it needs to be on the federal base level, not on just state, because as Tony mentioned, federal trumps state. So, let's go to the top. Let's don't start at the bottom. But that would be, I think, for most managers and owners, it would be a big help.
Yeah.
Okay. Well, I know Robin's involved locally with us from time to time in advocacy work, so maybe that's a conversation we'll have at the Realtor Association in the not too distant future. What other questions are on your mind?
I was just going to say that's something that the medical lobby might be able to help us with too, because it's against their best interests to have individuals engaging in this faux practice of medicine.
Right.
Faux practice. I've not heard that phrase before. I like it. Right. As practitioners, what else is on your mind, Brittany, Robin, and Joni?
I mean, mainly this is probably the hardest thing when it comes to being a property manager, is that we get these fake letters almost, I feel like it's every single time that there's an animal now, that it's something that they bought offline, or it's a letter that they pulled from, I got one from New Jersey the other day. And so it's just it is a headache, and you're always afraid to say something wrong or email something wrong in writing, or it's always just in the back of your head to make sure that you're not, because nobody wants to have a fair housing case against them or anything of that sort.
Because even if you're proven right, the expenses are astronomical.
Exactly.
And your E&O does not cover any of that. So there you go.
Exactly.
60% of all fair housing complaints right now are disability related. So this really is your most likely to get a complaint about something of this nature. So it's really scary.
Yeah. And I think what's sad is I think most managers and owners want to be accommodating, but they also know that, I mean, let's face it, we're all adults, and we know fake when we see fake. I mean, we know what they're doing. We know we've been doing this too long, haven't we, Robin, not to know when we're being conned. So that's what's so hard as well, is you're being conned and your hands are tied. And that's what's so frustrating, because those people who truly need it are being put into that same category. And it's sad because there are people who need this type of thing, but you've got those who want to abuse the situation. And I think that's what I would like to see, is those who are abusing it taken out, so that those who need it can get that service that they need. Because most of my owners are fine with it. It's just,
I would also recommend that if an individual does decide to adopt any kind of form or paperwork regarding this, that they have their attorney draw this up instead of just writing a couple of generic questions along those lines, because that can get someone into just as much trouble.
Absolutely.
I do have another question that just popped into my head.
Go ahead.
So I had a case previously where one of my residents had a significant other that had a service animal, who claimed to have a service animal, and they wanted to bring the animal whenever they wanted into the building. That person's obviously not a resident. So what can we ask then, or how do we handle something that it's a guest that's coming in and not somebody that we take care of?
When it comes to, you got to remember what the federal law states regarding serving all constituents and treating everybody the same.
Yeah.
Regardless if you provide services for that individual, the federal law pretty much states that individuals who need the service animal should have access to all public areas. So,
well, this isn't a public area. This is somebody's residence. Like, because at this building, it might be a building that doesn't allow any pets of any kind. But of course, we have to allow service animals, or this building has to allow service animals. So that is where in the past that has come up. And I was just curious how that would be handled.
My understanding is, like, for example, and Jennifer, you're an attorney, so you could clarify this, but typically when you have a service animal, they should have accessibility to any public area, or to visit, or to go to a store, to go to the library, to go to a restaurant. So I don't see why there would be a different issue if the individual needs this animal at all times to go and visit a family or a friend.
But the tenant is still ultimately responsible for their invitees' damages. So
exactly,
covered with that in the lease.
So, and again, as we said earlier, regardless if you have a service animal, emotional animal, if the animal does any damage to the property, that tenant is responsible for any damages.
Okay.
You do pose a really interesting question, though, because this does come up a lot, because your leases always say you can't have unauthorized pets. And that
exactly,
that includes visiting pets. So, And so I understand definitely the question. I think we have to treat it more like an ADA public accommodation thing, that the animal is walking through your public building to get to that residence, and we need to allow it. I wouldn't want to be the test case on that, but it's certainly an interesting question.
I think more fraudulent actions would form out of this, Brittany, like in this situation, because if they've got a relative or a family or a friend coming to visit for a couple of days, and they've got Fluffy the cat that they've had for 15 years, then they would be more prone to print something out to satisfy.
Wow, that's a hard one. I'm still trying to get my brain around. I understand what you're asking, but yeah.
Well, and we also got to remember, as baby boomers, all of us are getting older. I am in that category, but as we get older, we have those comfort animals, or we actually have a disability and we might need that animal. So we definitely have to have accessibility, because these animals are actually helping us in our daily lives. And we got to make sure we consider those factors in.
And so now this isn't a protected class at all, but I'm thinking about Brittany's scenario. So let's say I live across the breezeway or the hall, and that scenario happens, and I'm highly allergic to dogs. then at what point does that other tenant's rights come into play? And I guess it doesn't matter since that's on a protected class.
Again, the individual who has the disability is pretty much protected under ADA and fair housing.
Gotcha.
Now, if you have, for example, an employee, let's say an employee does have a service animal and you have an employee who is allergic, then the employer has to do some type of accommodation and arrangement to have them separated.
Sure. Okay.
But when it comes to somebody visiting your home and you have a neighbor who is allergic, you know, the disabled individual could still file a complaint, because if they need it, because they take care of them, if they have a seizure and that animal has to be nearby to give them support, I mean, the ADA is going to pretty much win.
So Jennifer, could an individual in this scenario, if I have the allergy and this pet that my neighbor has is infringing on my right to quiet and peaceful enjoyment, could I not petition the landlord at that point to let me out of my lease early? Is there, what?
Yes, and what the landlord would probably do in this situation would be to offer the resident a transfer to simply, you know, move them away from that resident, is usually how that would work. This brings up the point of my favorite story regarding this matter, just to show how much our courts are going to go on the side of the individual who wants that service animal. So I do volunteering at a place that's like a free hotel for cancer patients, and they do it, you know, nationwide. It's through the American Cancer Society. And there was actually a case there where someone sued them because they were told they could not bring their miniature horse into this free lodging for cancer patients where, you know, people are getting stem cell transplants. They can't be around a live plant, let alone a miniature horse. But still, they were sued and they lost. You know, that horse was determined to be so important that it didn't matter that it was risking the lives of all these other individuals. So that's just a crazy example that just shows us how serious this really is.
I tell you, guys, go to HUD and read the lawsuits and the results of them. It is amazing. I've done that a few times. Just, I don't know why, because I'm weird, but it's really fascinating to read some of these case laws and the judgments that come down. And I think it kind of puts the fear of God in you to understand what really is going on these HUD cases and what can happen. So, you know, if you're pretty, you know, you can stand there and fight and say, I'm right. But when you go read some of those case laws, it's pretty amazing where no matter how well you thought, and this is management companies that are doing some of these things. And you're just like, really? You really wanted to go down? I wouldn't want to be the test case either, and some of them, it's pretty amazing to see what they've gone through and the fines that they pay.
I so love that you're saying this, because I want to just point out to all my clients to go check that out, and don't get mad at me when I tell you, I know that's a complete and total lie, but under the law, we have to allow it. And so I think you just raised such a good example of why, because it might make you mad to have that pit bull on your property who, you know, really isn't a service animal, but it's going to make you a lot more mad when you get sued and have to pay a god-awful amount of money just to defend yourself. And then, God forbid, if you lose, the fines you'll have.
Yeah.
And we can add those in the comment thread on Facebook. We can add a link to those case studies. That's a great resource. Thank you for sharing that. What have we not asked you today that you wanted us to cover, or that you want to make sure that we drive certain points home to those of us who are watching this?
I know something that comes up a lot is, am I allowed to have more than one emotional support animal or more than one service animal? And the short answer to that is yes. If I have a letter that shows that, maybe I need my seeing eye dog, but I also need my emotional support gerbil, if all of that is appropriately documented, the answer is yes, you do have to allow it. Or yes, say you have 3 roommates and each one of them needs an emotional support animal and they have the proper documentation. Yes, you have to allow those too.
Okay. What else?
I think if other people are watching who are doing management and they're just not sure, always check with your attorney to make sure that you are doing the right thing, because you may think you know the answer, or you may think common sense is always the right way to go, but sometimes that's not always the case either. So always check with, I'm sure Tony wouldn't mind questions sometimes I would err on the side of caution, and always check with your attorney to make sure that you're not violating something that you may not even think about.
Jenny,
Yes.
that's a great point, and I've always been or have operated under that. We don't bring it up unless it has been broached by the individual that's filling out the application or that's wanting to lease the unit. And so that kind of, that was policy across the board, just to kind of protect everybody.
Right.
Are there some resources, Jenny? You mentioned you're a part of the Property Managers Association. Yes. I probably didn't get the acronym correct. And yes. Brittany, with the Apartment Association, are there resources that those entities have, either locally or nationally at that association level, that we could share?
NARPM, National Association of Property Real Estate Managers, is a national organization. We do not, unfortunately, have a local chapter. However, there are chapters in Nashville and in Atlanta. The thing I love about this organization is everyone's willing to share their experiences and what they have faced, and forms, or it's really an amazing organization. There is an annual dues, but it's worth it. It's been a really good educational thing for me, because unfortunately real estate boards typically they focus on sales more than on property management, which is what they do. And so I think that anything you can join in that regards, if you're serious about doing property management, is always a good thing. And they have lots of resources. They have a PAC. So, there's a lot of things that they're looking on our side of the industry to help in the federal and the state level. So.
Okay, we'll include a link to them in our chat too. What about you, Brittany, from the apartment perspective?
So the Chattanooga Apartment Association, if you're a member with us, there are annual dues as well. But you also have the resource to use all the National Apartment Association's database, as well as if you're a member of CAA, you're automatically a member of NAA. And anytime that you have any questions at all, you're always welcome to reach out, and we will do the best to find an answer for you or give you somebody who can help you. But there are several resources on the actual National Apartment Association website as well.
As NARPM as well. There's lots of information and links that you can go to for resources.
Yes. Okay, we'll go grab those links and post those. Jennifer, like you wanted to say something. Nope. Okay. Any other final closing comments or good stories, like the miniature pony? Or is that what you said? Yeah.
Yes. I just have something. It's just simple etiquette from individuals who actually utilize service animals. I am also part of the Mayor's Council on Disability. And some of these individuals who have a service animal want the general public to understand this, that if you see them out in the street with their service animal, please do not go and pet the animal. Please do not distract the animal. Do not try to feed the animal. The animal is a working animal. And if you do that, you're distracting that animal from providing the service that it needs to be doing. Unless the individual who is using that service animal tells you that it's okay. Just keep that in mind. You know, it's a working animal, it's not a pet. And that's one thing that they pretty much tell me all the time. I just wanted to share that with all of you.
That's some good etiquette suggestions. Thank you. And Josh is telling me he's posted those links. So thanks for sharing those with us. Well, we didn't quite go an hour, but I don't want to just keep us on here just to keep us on here. Any other final comments or thoughts before we wrap up? No? Okay. Well, again, thanks to Josh for pulling this panel together, and thanks to each of you, Brittany, Jennifer, Tony, Robin, and Joni, for spending this hour with us this morning to let us pick your brain and answer your questions. And you're right, Joni, it's you are all our members too, but it's not a segment that we focus on often. So we at least wanted to try to. Robin's shaking her head. She's like, I'm always telling you. So if you have other suggestions of these kinds of topics or sessions that we could do to help get your questions answered, maybe do some advocacy work or educate just the general realtor or general public, we'd be glad to accommodate those. So I personally learned a lot. This was certainly an area that I didn't know a lot about. So I thought it was very informative, and I appreciate your time and perspective.
Thank you, everybody.
Thank you.